Richmond is attorney Stephen Gusick.
All right, counsel for the appellant, please introduce yourself and your client. You may proceed with your argument. You have 5 minutes.
Thank you, Your Honors. My name is Christian Chorba. I'm an attorney at Downs, Racklin, Martin, representing appellant Scott Bedell in this matter, Bedell v. Richmond. Your Honors, affirming the Civil Division's decision in this matter would severely threaten decades of well-established precedent from both this court and courts around the country that a prescriptive easement's historic use is what determines its scope, and that the owner of a prescriptive easement may not upgrade or expand that easement beyond that historic use. As we have briefed, this case focuses on whether defendant Catherine Richmond has a prescriptive easement to route water from a surface spring located on Dr. Bedell's property, which we call the Bedell property, through an underground pipe passing under an intermediate property owned by Laura Todd, the Todd property, and finally to Miss Richmond's own property, the Richmond property, which is over a third.
Are there two issues? One being the spring itself and the spring house, as it's called, and the second being the piping system from the spring to the house?
In a sense, those are two issues, but they're so interrelated. I frankly view them as one, because yes, there's the infrastructure at the spring itself and what sort of maintenance or improvements or upgrades you can do at the spring itself, which is located on Dr. Bedell's property. And then there is the pipe that presumably goes from that spring passing under his property, then through the intermediate property owned by Miss Todd, and then finally to the Richmond property for use at her home.
And the only reason I ask is that, I mean, the spring itself is basically immovable. You can't really move the spring. You may be able to, I guess, enhance it or build another building around it, but that's set. The piping can be changed at any time depending on the circumstances. And it sounded like throughout the history here that the piping location had been changed. And that's the only reason I'm asking the question is there a scope issue regarding the pipe?
Yes, there's definitely a scope issue, I think, with both the spring and the pipe. Because with the spring, yes, the location is set. There's no doubt about that. However, you can someone can do various things to expand the scope of a spring, such as dig it deeper, build more around it. There's currently, there's questions about, can you lock the spring? Can others make use of the spring? There is also the fact that the spring is located very close to my client's horse pastures, various buildings he owns. And fortunately, the trial court did clarify that my client's activities around the spring will not be interfered with. As to the pipe can also be modified or enhanced as to the width of the pipe, as to its location going over my client's property, as well as to the depth. And so, yes, these are two different pieces of infrastructure, the spring and the pipe. However, both can experience or will require maintenance, and both can experience various types of upgrades or enhancements. And so when we're looking at the pipe, the biggest issue is whether or not any upgrades or enhancements to it would necessarily mean an undue interference with my client's own property. Again, that pipe passes under my client's horse pastures, other portions of his property, and therefore moving the pipe, digging it deeper, which the trial court said Miss Richmond could do, or expanding its width, all of those would pose unnecessary and undue interferences with my client's property.
But would the change in the pipe itself, I'm reading your papers to say that would be an undue expansion as well if the pipe was changed.
Yes, if the pipe was changed, currently, as far as we know, the pipe is functioning as it essentially always has functioned. It has never functioned 100% perfectly. There have been periods where the water has gone dry, where the pipe has frozen. But again, digging it deeper would pose an undue interference with my client's property.
What about changing the pipe from whatever it's currently made of to PVC or something
Again,
like that? You say
again,
that's an undue influence too?
that would also be an undue interference because it would require digging up my client's property, interfering with his horse pastures, and then, of course, just to really narrow in on it, the trial court's order expands that piping system as well as the infrastructure at the spring beyond its historic use. It has to be, that use and the infrastructure must be cabined by the historic use. So upgrading at this point to PVC piping is an illegal expansion of a prescriptive easement.
So when the pipe fails, do they have any right to go in your view, to restore the flow?
Yes, I think if the pipe fails, ordinary maintenance, and I have cited case law regarding ordinary maintenance, we don't have an issue with. We have an issue with expansion. And again, the case law is extremely clear that expansions and enhancements beyond historic use are not allowed. So,
but they have to repair it using the materials that are already in use. So
yes,
the log with the pipe driven down through the center, they have to put that back in when there's a failure?
Well, so that the log with the pipe in the center, that was dating back decades ago. At this point, that's no longer
there now.
No, the log with the pipe.
How did it get changed if that would be an upgrade? That was because nobody objected?
I think that's the issue. Nobody objected.
If you had been around and objected at that time, your point is they have to stay with that same material.
They would have to stay with that same material. That's correct, Your Honor. I think that in general, the court made several correct decisions, and I've highlighted those in our briefing. However, where the court erred is essentially saying that there was a trajectory, a general trajectory over the past several decades whereby this pipe was enhanced, and therefore that trajectory can just continue. And there can be future enhancements. However, again, the case law is very clear that no, the prescriptive easement is essentially remains where the historic use is, and therefore whatever use is currently going on cannot be enhanced. You cannot continue any sort of
Mr. Chorba, when you use the word enhanced, and it looks like your time may be up, but when you use the word enhanced, do you mean the increase in flow or a different material, or like a modern material?
Yes, referring to both, although frankly, so we would object to a wider width pipe, different material, but then also, again, a very big thing is the depth of the pipe.
Because you have to leave it there, Mr. Chorba. Your time is expired.
Okay. Thank you, Your Honors.
Thank you. All right, counsel for the appellee, please introduce yourself and your client, and you may proceed. You're muted, sir.
My apologies, Your Honors. My name's Stephen Cusick. I represent appellee Catherine Richmond. I'm with the law firm of Main Street Law in Montpelier, Vermont. I'd first like to address some of the issues that were raised by the previous questioning there over the use of the alterations to the pipe on the property. In 2006, the pipe was rerouted and the size of it was increased from 3/4 of an inch to a full inch. That's only one of many changes that have occurred to the piping and in some ways to the spring over a period of years dating back to the 1940s. So I don't think it would be correct to assume that this is just a static circumstance. The problem, I believe, with appellant's argument is they're conflating the infrastructure with what the actual purpose of the spring is itself, and that's to provide water at a consistent rate to the owners of the farmhouse property, which at this point in time is my client.
And Mr. Cusack, is there any evidence whatsoever that this wasn't just for home use, personal use at the farmhouse?
Oh, yes, Your Honor, if you actually if you review the record, you'll see that both during the prescriptive easement and prior to that, it did not only supply the needs for the household use and at an adequate rate, I might add, but it also provided an adequate supply for livestock that the multiple property owners had on the property, dating back to the 1940s when they had like 40 head of cattle on the property. My client has no livestock. I don't know if she intends to get one. She want to put some gardens on the property, so there would be use for that. But I think the trial court was wise in making clear that my client cannot expand the natural water flow there. So that deals with the issue of overburdening the spring or going beyond the scope of the water flow of the spring. My client cannot share the water with other properties or divert it to other properties. And there, if you look at if you look at the remedies the court provided in this case, there are several other restrictions on that ensure that Mr. Bedell is adequately protected. And I would posit that although the appellant uses the terms outsized and extreme regarding what the judge's order would do, I think, frankly, Your Honors, that is a ridiculous argument. Things aren't going to change at all. This is just going to be consistent with the historic use of the property as defined during the prescriptive period from 1994 to 2009. And that prescriptive period will show that there are households that had up to 7 people there who used that spring and had an adequate source of water, that these households had livestock, that they were able to rely on that spring for their households and their livestock, that they had free access to make improvements to the spring box, which they took advantage of. They had to go up there and to shock the spring every year to provide, shock it with bleach to provide to combat bacteria. So what the clear dispute in this case is over the conditions 1 through 6 that the court lays out on pages 8 and 9 of the decision. And those deal with my client's rights. Those rights are reasonable. They're consistent with the testimony that was given at trial as to the historic use during the prescriptive easement. And frankly, you could take it prior to the prescriptive easement back to the 1940s based on Mr. Robert Hamel's testimony at trial. I just, and to say that there's going to be an outside burden on him, Mr. Bedell's not going to, he's not going to suffer any burden from this any more than he already has since he took ownership of the property in 2011 after the spring rights had already vested in the property. I would ask the court to affirm the trial court's decisions in this case. I think it is a reasonable decision, and it is certainly consistent with the historic use of the spring as testified to at trial. Thank you, Your Honors.
All right, thank you. Appellant's time has expired, so the bailiff may call the conclusion of this case.
The next